Citizen?
Yes, Judge. Just wanted to show you a video, see if you could authenticate for me. No, obviously you didn't take it. But,
Are you going to play it on the big screen for everyone to see?
well, I don't know if I know how to connect it. I was just going to show him, and if he can authenticate it, then I was going to introduce you as an exhibit.
I've seen it, Judge, so I'm fine with you to show me.
Yeah, I should.
George? Oh, missed it. George has caught the ball. Hooray! Well done, George. Now you throw the ball to Pepper. Oh, try again.
Put her down for this. Pass was long.
Again.
And this one.
George cannot throw the ball past Muddy Pig. Come on, George. Give it to me.
My kids are here by themselves. I understand that. I'm not. Turn around, put your hands behind your back. Yes, sir. Did you not hear us knocking on the door? I heard somebody knocking, but I thought it was mine. You didn't hear me yell at the police department? No, sir, I did not. You know why we're here? I have no idea. Okay. We'll get to that. Hey, you let them know that they can come in here for these kids now? That's my mom. Hey, Mom. Is that your mom? Who is she? Salem Miller. She's there, Dad. No. So you taking my kids? I'm not.
So, I know that you're not the one who took that video, but would you say that that fairly and accurately depicts you arresting Mr. Beard on the date that you were testifying to? Okay, so that's an objection. I would just introduce a USB stick with that.
I won't be considering it because I haven't watched it. But
Well, I was going to publish it next.
there you go.
How would you like me to publish it? I guess.
Well, it doesn't matter to me how you wish to publish it, but if you're showing him a video, and if I'm going to have to consider it, I'll have to watch the same video. It would have been probably easier to put it up there, but it doesn't matter. Are you wanting me to watch it? Is that correct?
Yes, Judge. If you just want to use my laptop, I figure that might be the easiest. Unless there's like a HDMI I can plug into. Should be more prepared for that, but just kind of. Here you go, Judge.
George? Oh, missed it. George has caught the ball. Hooray! Well done, George. Now you throw the ball to Pepper. Try again.
Put her down for this. Pass was long.
Again.
And this one.
George cannot throw the ball past Muddy Pig. Come on, George. Give it to me.
My kids are here by themselves. I understand that. I'm not. Turn around, put your hands behind your back. Yes, sir. Did you not hear us knocking on the door? I heard somebody knocking, but I thought it was mine. You didn't hear me yell at the police department? No, sir, I did not. You know why we're here? I have no idea. Okay. We'll get to that. Hey, you let them know that they can come in here for these kids now? That's my mom. Hey, Mom. Is that your mom? Who is she? Salem Miller. She's there, Dad. No. So you take my kids? I'm not.
With that, Judge, that's all that I have of this witness.
Redirect?
Yes, Judge. And Officer Field, you saw the video that you were just showing, correct?
Yes, ma'am.
And you've been testifying from your memory up to now, correct?
Yes, ma'am.
You were never able to review your body cam footage
No, ma'am.
due to it being lost?
Yes, ma'am.
And in that video, you can see one of the children in a playpen, correct?
Correct.
Having watched that, does that refresh your memory as to what,
It does.
can you tell the court specifically what you saw that day?
I would just say that it's walking down the hallway, obviously a very stressful situation. I distinctly remember seeing a child on each side of Mr. Beard. I distinctly remember Mr. Beard when I told him to come to me. I said the word usher. I'm not sure what the best way is to describe it. The child that was next to him, I'm not sure if the child was on his lap or on the bed. I don't dispute the video, but
You do recall seeing a child being, well,
yes, ma'am.
between you and him,
Yes, ma'am.
at least one child.
Yes, ma'am.
Okay. And again, just for purposes of refreshing the court's memory, the door was barricaded.
Yes, ma'am, it was. And photos were taken of the crib that barricaded the door.
Okay. And is your testimony true and accurate to the best of your knowledge?
Yes, ma'am, it is.
And this happened back in January of this year, correct?
Yes, ma'am.
No further questions.
Recross?
Very brief moment, Judge, and just
You testified that you took a photograph of the baby gate that was in front of the front door, that was behind the front door.
yes, sir.
That's all.
Nothing further, Judge.
Thank you, officer. You may step down. State, you may call your next witness.
Your Honor, state will call Caitlin Miller.
Caitlin Miller. Well, if you'll come out around here, please. I ask you to raise your right hand and face the clerk.
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes. Thank you. Now state your name.
Ms. Miller, can you state your full name for me, please?
Caitlin Burnett Miller.
Scoot up to that microphone. Everybody has a hard time, but you have to basically directly speak into it for the pickup. Okay.
Ms. Miller, were you in a relationship with Mr. Ethan Beard?
Yes.
Okay. And did that end back in January of 2025?
Yes.
Okay. And
Speak up now.
Yeah, you're gonna have to really
This
get
lady
close.
here on this side of me has got to write down everything that you say. So when you
Okay.
talk softly, she can't hear you. So be sure to speak up.
just as loud as you can. You live in Humphreys County or in the city limits of Waverly with Mr. Beard, correct?
Yes,
Okay. And what was your address at that time
106 Powell Avenue,
in Waverly?
Waverly.
Okay. And did you speak with Officer Floryfield of the Waverly Police Department back in January 2025?
Yes.
Okay. And what did you tell him?
He came to my mother's home, which is where I was at the time, and told him what my 8-year-old son had told my ex-husband and the abuse that had been going on with us and the children.
Okay. Did you specifically tell him about several instances where you were assaulted by Mr. Beard?
Yes.
Okay. Can you tell the court about, well, whether or not it was physical abuse or what kind of abuse it was?
Physical and mental.
Okay. And how did he physically abuse you on the occasions that you told Officer Field about?
He tied a hoodie string around my throat and tried to strangle me. I had a bruise on my arm from where he punched me. I had an imprint of a water bottle on my side where he threw it at me
What kind of water bottle?
Dasani.
So that would be a metal or plastic? or-
Plastic. He pushed me over on our 3-year-old daughter, trying to get a hold of my neck.
Did he grab you by the throat multiple times?
Yes.
And when he grabbed you by the throat, how did he grab you?
With both hands trying to strangle me.
Did it leave marks on your neck?
Yes.
Did you take photos of those?
Yes.
Did you provide those to law enforcement?
Yes.
Did he also threaten to kill you or harm you?
Yes.
What specific threat did he make?
That he would put me 6 foot under the ground and make sure that I didn't breathe again.
Did he also threaten to slit your throat?
Yes.
What did he say when he was saying that?
That he was going to, I don't want to cuss,
It's all right, go ahead.
that he would slit my throat if I took his children away from him.
Did he ever hit you with his fist
Yes.
more than once?
Yes.
And can you tell the judge the approximate time frame that these incidents occurred?
No, October, November, December of 2024.
And you have photos of multiple injuries, correct?
Yes.
And you documented those and provided those to law enforcement?
Objection,
Yes.
leading,
Saying don't lead the witness.
You took photos of the injuries?
objection.
Oh, let me rephrase it, Judge. Did you take photos of the injuries?
Yes.
Did you provide those to law enforcement?
Yes.
How did you provide those to law enforcement?
I believed they were time-stamped photos that were either airdropped or sent to him to his email.
Did you have any other photos that you provided to law enforcement?
I provided everything that I had that night.
Were you aware that Mr. Beard had broken the lock on the water meter, or whatever it is that you're at the residence?
Was not.
You were not aware? You're aware that the water that you had was not being paid for?
No.
In fact, did you give Mr. Beard any money?
Yes.
What did you give him money for?
The water bill and multiple other things. I mean, he didn't work
How long a period did he not work for?
the entire time we were together, 5 years.
And you worked,
Yes.
were you working pretty much the whole time?
Yes.
So he was home alone with the children the majority of the time? Are you afraid of Mr. Beard?
Yes.
Did Mr. Beard try to contact you once he was in jail?
Yes.
Did he speak with you on the phone?
I never spoke to him on the phone.
But did he talk, did you answer a phone call from him?
Yes.
Okay, and he spoke
And
to
he
you?
spoke, yes.
And did he try to call you multiple other times?
13 times.
And this was after he had been arrested and in jail, correct?
Yes.
No further questions, Judge.
Sensing, you may cross-examine.
Do you recall roughly when the last phone call was?
The last phone call that he, from
Yes,
jail,
that you received from him?
I believe it was January 17th. It was the night my dad died. So the 17th.
And, okay, so I kind of want to ask, there's some questions about the photographs you sent to Officer Field. You testified that you may have airdropped it to him, is that right?
Yes.
Okay, so you took those photographs with an iPhone, an Apple iPhone?
Yes.
Talking about the water issue, you testified that you didn't know anything about the water issue. Is it fair to say that you had informed Officer Field on January 12th that Mr. Beard was the one giving you money for the water bill?
I gave him money for the water
Or
bill.
sorry, that you gave Mr. Beard money for the water bill?
Yes.
And that was reported to Officer Field at the same time, like when you first spoke to him?
I believe so.
When did you go to change the water into your name?
I don't remember the exact date. 2 weeks, a week or 2 weeks. I don't remember the date.
After Mr. Beard was arrested?
Correct.
Now, Mr. Beard is charged with two counts of this assault, right? One on December 1st, one on December 2nd. Do you recall what happened on December 1st of 2024?
I don't remember the exact dates.
I'm asking you specifically about the time in which Mr. Beard was alleged to have threatened you.
Okay.
On December 1st. Do you recall that?
I don't remember specific dates to each threat, no.
There's one where he said that he would slit your throat if you took the children away.
Okay, yes.
Do you recall what was the context in which that was said? Like what was going on? What happened before that?
Usually me complaining about him getting a job and helping with bills would start the argument.
Do you recall specifically if that's what that was that day?
I don't recall specifically, no.
Do you recall whether you took notes about it, or how did you recall that it had happened when you spoke to the
I
officer?
have photos that are time stamped, and I do have notes in my phone, but sitting here right now, I don't remember specific dates.
When he threatened you to slit your throat, I mean, did he have a knife?
No,
Do you recall making a written statement that gave sort of a timeline of all of the abuse to Officer Field?
yes,
And to the best of your knowledge, that written statement contain everything that you recalled at the time?
yes,
So if that written statement on December the 1st just said the only thing that it included was the threat that he would slit your throat, but there wasn't any sort of physical abuse, would that be accurate?
no, there was physical abuse.
I mean, on that day.
I don't remember specific dates.
I'd like to show you a document just to refresh me.
Okay. Okay.
Was there any, to your recollection, did you allege that he physically assaulted you on December 1st, or was it just the threat?
No, he put his hands around my throat.
On December 1st?
Yes.
Is that reflected on that written
multiple
statement?
occasions. He grabbed me in the living room and pushed me on top of our 3-year-old daughter.
Okay, if I may retrieve it. If I could show that to you again, does that say December 1st or December 2nd?
December 2nd.
So would it be fair to say that that was December 2nd?
Correct.
So what you put in that written statement about December 1st, is that accurate?
Yes.
And good. Was there anything on December 1st about him putting his hands on you?
Specifically on December 1st, correct? No.
But other than what's in that written statement about that specific date, your testimony is today that you don't have a clear recollection of what happened?
I do have a clear recollection. I just don't know specific dates.
Well, that's what I'm asking. You can't really differentiate what happened on this date versus that date.
Sure. Okay.
That's all, Judge.
Anything further from the state?
No.
Thank you, ma'am. You may step down. State may call your next witness.
state has no other witnesses to it.
State has rested their proof. Do you have any rebuttal proof, Mr. Sensing?
No, Judge.
All right, I'll hear an argument.
I did a little reading during lunch. I think that at the outset, it's important to remember that what we have here before the court today are a set of allegations. A set of allegations that are unproven and that have not been subjected to a jury trial, in which Mr. Beard stands presumably innocent. And so this court's job, as I'm sure it well knows, is to determine what is the least onerous conditions that are necessary to make sure that Mr. Beard appears in court and to make sure that Mr. Beard isn't going to be a danger to the community upon release. And there are a number of factors that I think I'll get into, but which point towards either giving him a signature bond with a GPS monitor or giving him a bond of no more than $5,000 or $10,000 bail amount. So starting with the fact that it's undisputed that Mr. Beard has been a resident of this county for his entire life. He has no meaningful context outside of this county. He is not a flight risk. So in terms of making sure that he's going to appear in court and run away, I mean, there's no evidence that would support that at all. As he has no criminal history except a B misdemeanor driving on a suspended license. He has no record of any failure to appears. And certainly he doesn't have a criminal history that would suggest that he's at all a danger to the community at large. He is, even if he is convicted. Well, let's talk about the strength of the state's case, starting in 15063, water theft. If the court looks at the bill that I tendered as an exhibit, you'll note that the only water that was actually stolen, this is a theft of property case, it's like $500 or $600 worth of water. Now, maybe the state has a case about a misdemeanor theft, but in terms of this felony theft, where they're including late fees and broken lock fees, service fees, and all of that, that's not what was stolen. Okay, so this is not a felony theft case. It is a misdemeanor theft case, and it is a misdemeanor theft case in which the vandalism charge was filed outside the statute of limitations. If Mr. Beard had been stealing water allegedly since January of 2023, the lock would have been cut then. This was not filed within the year. So the state's strength on the vandalism count is non-existent. Turning to 15064, in its amended response to my motion for a bill of particulars, the state has amended its indictment or superseded its indictment to charge Mr. Beard with child endangerment. It claims it's a B felony. But if the court looks at the statute, that is child endangerment by exposure to a non-Schedule 6 controlled substance. And there's absolutely no evidence at all to suggest that Mr. Beard is guilty of that. And even if Mr. Beard was guilty of the A misdemeanor child endangerment, which would have been the proper charge, there's no evidence that he placed his children in imminent risk of harm. There was never a gun pointed at them. There was never a taser pointed at them. There's no evidence on that video that he ushered them in front of him to try and blockade them between him and the police. And he's not charged with any of this 404B evidence about the house or the bruises or this and that. He's only charged with child endangerment. And if the court looks at the state's amended response to the bill of particulars, the allegation is that he put his children at risk if he failed to answer the door. Weak case. Possession of unlawful drug paraphernalia, well, there was no marijuana found, and there's been no testing to show that it had marijuana residue on it, so I would argue that that's also weak. 15065, the A misdemeanor domestic assault, aggravated assault, violation of no contact order, that sort of stuff that's going to have to go in front of the jury. Obviously, the allegation has been made over a month after the fact in the context of a different investigation entirely. But whether or not if that's sufficient proof beyond a reasonable doubt, she says there's photos of these injuries. They are not in evidence before this. All we have is her allegation that it occurred, and she testified that she had no clear memory about what happened. And then again, there's all this 404B propensity evidence that was put on that is not relevant to the crime for which he's charged. His bond is currently set at $75,000. And at the end of the day, I think the state's going to get, at best, some misdemeanor convictions and maybe a C felony aggravated assault. And if the court looks at TCA 4035-1026A, he is a presumptive candidate for probation. He has no criminal history. There have been no efforts to rehabilitate him that have failed. He will be guilty of a C felony, which makes him a presumptive probation candidate. So he's likely to get a probated sentence where he to be found guilty after trial. I don't mean to presume, but that's what the statute says. So in terms of the proof, strength of the state's proof, and the likely sentence that he would receive if convicted, I would say that those don't bear upon him being a flight risk either. People get probation for these sorts of things all the time. And again, I'm not trying to put words in the court's mouth, but we'll see what the proof comes out of trial and the sentencing. He has multiple members of the community who vouched for him, multiple members of the community who gave testimony that are at stark contradiction to what the state's trying to paint here as far as Mr. Beard being this abusive person. And so when considered in the context of, is he going to appear in court? Is he going to go out there and terrorize the community if he's released? And he's presumed innocent. All of these factors favor releasing him on either a signature bond with a GPS monitor, no contact order with Ms. Miller and the children. And I should say, the violation of the bond conditions, I think officer, we don't have the recording, but Officer Field himself testified that he got through to her once and he wanted to apologize. That's what he wanted to do. That's why he called her. He didn't call her to threaten her. He didn't call her to try and tamper with her testimony or anything like that. So if the state gets up here and says that he's a danger to her because he violated his bond restrictions, I think it should be said that the reason that he didn't care if he got into trouble, maybe he will, is because he felt like it was important to apologize. Is it wrong? It's illegal. But does that show that he's a danger to her? I don't think it does. And so what I would ask the court to do, in consideration of Mr. Beard's fundamental right to be released on its minimum amount of bail conditions as is reasonably necessary to make sure he shows up to court and doesn't reoffend, I would ask the court to, like I said, either give him a signature bond with conditions that we have a GPS monitor so that we can keep tabs on where he is, he's not going around her or the kids, or set bond at no more than $5,000. Thank you. I think I put $10,000 in my motions.
General McCloud?
Yes, Judge. Judge, first of all, state would disagree with defense counsel's summation of the strength of the state's cases here.
Shocking.
Starting with the vandalism and theft case. Your Honor, it's the state's understanding that the statute of limitations activates, for lack of a better word, once the victim becomes aware of the crime. The city of Waverly was not aware that the lock had been broken. Now, whether they should have been aware or not is another question, but they weren't. When they did become aware, they notified law enforcement immediately, and he was charged. The state also disagrees with defense counsel's assessment that it's only a misdemeanor theft as opposed to a felony theft. But again, the state does feel that is a matter to be addressed at trial and a jury question. As far as the aggravated assault, the state believes it does have a strong case. Your Honor, the state didn't introduce all the photos because again, it's a bond hearing, not a trial. But there's the victim testified, the officer testified separately, the victim was outside when the officer testified. Their testimony corroborated one another. Photos have been provided, defense has those photos. The state believes that the assault case is very strong. that there will be a conviction. And further, the state would argue that aggravated assault is in the category of crimes that is not listed as probatable if convicted in a jury trial. I understand the court would still do that, but it's not necessarily clear that that is a charge once convicted that one could be put on probation for. Moving to the child abuse statute, Your Honor. Defense argues that 3915-401D1, which reads in full, any person, let me find it. Make sure I reference the right one. Any person who negligently by act or omission engages in conduct that places a child in imminent danger of death, bodily injury, or physical or mental impairment commits a Class A misdemeanor, except that if the abused child is 8 years of age or less, the penalty is a Class B felony. So Section 2 then goes on to say, for purposes of this subsection, a person engages in conduct that places a child in that situation if the child is exposed to a drug that's not Schedule 6. The state's reading of that statute is that that is simply one aspect of what the statute is intended to cover. It's not necessarily reserved exclusively for children exposed to drugs, but for any conduct that can put a child in that danger. That's why Mr. Beard was indicted under that statute, due to the state's belief his actions would fall into that category. The state disagrees that that law would apply only to drug offenses. The violation of bond conditions. Mr. Sensing seems to think that, or his argument at least, is that the defendant's violating of his bond conditions can be excused if the purpose of the defendant's phone calls are to apologize to the victim. The state would argue that perhaps Mr. Beard was trying to influence or coerce the victim to drop her allegations, maybe accept his professions of being sorry and let him off the hook. So the state doesn't believe that his apologies are sincere. In fact, the state would argue that his conduct in repeatedly violating those bond conditions, while stating that he was aware that he knew he was doing so and would get in trouble, shows a complete disregard for the law and for orders of the court. And again, Your Honor, this is a bond hearing, it's not a trial, as you're aware. Mr. Sensing states in his motion that the state has submitted no evidence or articulable allegation that would, if true, make the defendant guilty of child abuse and neglect. And the state just simply disagrees with that. We believe that the evidence is overwhelming in this case, Your Honor. Yes, the pipe wasn't checked for marijuana residue, but the jury can determine whether or not they think it was being used for that, or he was just smoking tobacco out of it. Your Honor, the state does agree that under the bond statute, there are multiple requirements and factors that the judge would look at. And several of those do favor defendant as far as length of residence in community, members of the community to vouch for him, the fact that he has a very minimal prior criminal record, that he wasn't already on release when he committed the majority of these offenses or is presumed was charged with them, except for the violation of bond conditions. But Your Honor, the state does feel that based on the testimony we've heard today, that the probability that he would be convicted of the majority of these offenses is a great probability, that he is a danger to the community. Based on the testimony, Your Honor also heard that there are other children in which he has not been charged that also have bruises and marks of abuse on them. As far as employment, we heard that he hasn't had a job for 5 years. That would also favor the state. But in summation, the state would say that the bond of $75,000 is more than appropriate. But if Your Honor does feel inclined to lower that at all, the state would ask that he be required to pay for a GPS monitoring device and also pay for the victim to have the notification as well. Thank you, Judge.
Respondents to,
We may.
first of all, Got the jury instruction here. With respect to this B felony child endangerment, it's an act. It's an uncontroversial canon of statutory construction where the statute embraces a something general, and then something specific. Specific part should be limited to that. This statute, 3915-401, already has a child endangerment. That's a general child endangerment, and that's in subsection C. It's a class A. Then, in subsections D and E, it has special drug exposure child endangerment. And the fact that it has one for meth and for fentanyl underscores the fact that those two subsections are limited to drug exposure by a methamphetamine or some other non-Schedule 6 controlled substance, which includes marijuana, Schedule 6, or again in subsection D2, fentanyl, which increases the penalty to an E felony rather than an A misdemeanor. So, respectfully, I think that Tennessee Sentencing Commission, when they wrote the jury instructions, agreeing with my interpretation, and I can't see any appellate court not agreeing with my instructions. So it's an A misdemeanor child endangerment. Again, if it's child endangerment at all, there's no imminent threat that I heard today. And the next thing that I want to address is the state's talking an awful lot like he's already been convicted and we're at a sentencing hearing. We're not here to punish Mr. Beard for what he may have done. We're here to assess is he a danger. And again, these bond violations, there's nothing that the state's speculating, well, maybe he was trying, even though he didn't say anything that would suggest that he was trying to influence her testimony, maybe because he felt bad and apologized, he had this plan to try and get her to change her testimony, even though that wasn't expressed. So does that make him a danger to her while he stands presumed innocent?
Can I respond to? I'm
You
sorry.
may, the public defender will have the final say no matter what, but I'll give you another opportunity if you want to respond.
Well, Judge, I was just wanting to say that the state's argument is based on Mr. Sensen's argument that we don't have, the likelihood of conviction is low. We know we're not in a sentencing hearing. But I did want to briefly point out that looking at the statute for child abuse and neglect, 3915-401A refers to a person who knowingly and other than by accidental means inflicts injury on a child. Subsection B refers to a person who knowingly abuses or neglects a child to adversely affect their welfare. And subsection D, which is the one that he's charged under, refers to negligent acts, including it's just by act or omission. So the state would argue that different things are being met by each statute. And this subsection D is referring to negligent behavior. It doesn't have to be intentional. That's all the state wanted to say.
Citizen, you have the final say.
Other than the fact that if the legislature were to criminalize negligence in such a way that you might potentially, possibly put a child in imminent danger would be horrifying. But also, it stands to reason that if negligence is the standard, then it's exposure to a controlled substance. And again, she overlooks, she goes through subsection A and subsection B, skips to D, because C is where you have child endangerment by a parent who has a parent or custodian who actually has the duty to care for a child, puts them in imminent danger of death or serious bodily injury. And I suppose I'll end with this from Professor Lawrence Tribe, and it's a quote that I think bears sayings from the law review article that I heard at our conference, and it's this. Quote, the system will appear to be it's about bell arguments. The system will appear to be malfunctioning only when it releases persons who prove worse risks than anticipated. The pretrial misconduct of these persons will seem to validate and will indeed augment the fear and insecurity that the system is calculated to appease. But when the system detains persons who could safely have been released, its errors will be invisible. And so this court errs too harshly on Mr. Beard, if he could have been released with the least onerous terms possible to ensure that a man in a free country who stands presumed innocent until proven guilty doesn't stay incarcerated for over a year for crimes for which he has not been convicted. I would just ask the court to account for that too, because I know all too often, all the weight's on danger of the community. Somebody gets cut loose and they do something bad, it makes us all look bad. But I think that we should pay attention to the other side too, because again, it's part of what makes this country great.
Well, what makes this country great is the fact that we do have a system of laws and rules, and we have a constitution that guarantees people to have certain rights that are protected by law. One of those rights is the fact that a person is presumed to be innocent. So we have that argument to make that this public defender has certainly made many times here today, is the fact that Mr. Beard has not been yet convicted of anything. So the court has to consider the evidence that is presented at this hearing. And the evidence that has been presented at this hearing is consisting of multiple people who have testified about Mr. Beard and his conduct and his character and so forth, and the type of person he is and how he's nonviolent and so forth and so on. Contrary to that, and how he's reliable and all of those things are presented as a means of trying to satisfy some of the factors that are set forth in the bail statute. And I'll touch on those in a minute. The state has presented evidence through the testimony of the officer and the victim of the alleged victim in one of the cases that tends to contravene or contradict the testimony of all of those character witnesses of Mr. Beard. So the court is cognizant of the fact that this is not a trial on the merits and beyond a reasonable doubt, and that is not the standard that the court applies in a bond reduction hearing. So we can argue all day long that a person is presumed to be innocent, and certainly under that, everyone would be released without any kind of restriction on their liberty because they're presumed to be innocent. But our law provides that there are certain factors that must be met, and that a recognizance bond or a bond of appearance can be required of anyone who is charged with a crime. And while Mr. Beard is not yet convicted of anything, one of those charges is a very serious charge of aggravated assault by strangulation. Now, the court is aware of the fact that while he has not been convicted, and Mr. Sensing argues that these are allegations that are unproven, there is truth to that. But for the purposes of this bond hearing, this court finds that the credible testimony of both the officer and the victim in the case established that there is a high probability that the defendant is in fact guilty of these offenses, based on the uncontradicted testimony of the victim alone, that he did in fact attempt to choke her and did in fact threaten her and so forth. Yes, that is not proof beyond a reasonable doubt, but that's not the standard for a bond hearing. The bond hearing is for me to determine what factors there are present and what factors would be required. The fact that he violated his bond conditions by contacting the victim, attempting to contact her by the evidence 13 times, and only connecting with her, answering it one time, and then, as Mr. Sensing points out, he may have done so to apologize. Anyone who's dealt with domestic violence cases on a regular basis, and I've done it for longer than I would care to remember, there is a pattern. And we often wonder, why do victims of domestic abuse, especially women, continue to stay in relationships where they're abused? One of the patterns that we see consistently is that that person says, well, he's promised to do better. There was a promise that I'm sorry, I apologize, I'll promise to do better. And so they stay with them because they have children or other factors. So the fact that Mr. Beard contacted the victim in violation of the bond condition, in this court's opinion, just to apologize is nothing more than consistent with what abusers often do in cases involving a victim. They try to apologize to try to lessen the punishment that might be inflicted upon them. So those are the findings that I make specifically, factually, in this particular case. Applying my findings to factors that are set forth in 4011-118 of the Tennessee Code, which have to do with the amount of the bond and the factors to be considered. The court looks at the defendant's length of residence in the community. He's a lifelong resident of the community, and that is a factor that favors him. 2, the defendant's employment status and history and financial condition, provided that his ability to pay shall not be considered. He is not employed, and therefore that's a factor that does not favor him. 3, his family's ties and relationships. He obviously has family ties and relationships with friends and people who have come to court to testify for him. That's a factor that does favor him, although clearly their opinion of his personality and so forth runs counter to what some of the other proof was in this case. That's not always unusual for someone to not, a family member to not always see the other side of the family member's character. The dependent's reputation, character, and mental condition. Again, the evidence of character here has been introduced is the family members and friends of the defendant who vouch for his reliability and trustworthiness and so forth, and the fact that he's not a violent person. His prior criminal record, he has no prior criminal record. So that would be another factor that would favor him. Nature of the offense and apparent probability of conviction, likely sentence. Again, the argument is made that he's not yet been convicted, but the proof that's been presented at this hearing presents a strong case that indicates that if these photographs are introduced at trial, if in fact he has done these things, that there's a, and the evidence before me at this hearing is that there's a strong case that he has likely committed the assault against his girlfriend and Ms. Miller, and that the fact of the matter is that it's a strong likelihood that he may be convicted of that case. He is charged in that particular case with domestic assault and aggravated assault in violation of a protective order. No question he violated a protective order. Even Mr. Sensing admits that, but minimizes it by saying he was just doing it. He was violating that to apologize. And in the testimony before me was he knew he was doing something that he wasn't supposed to do, but he did it anyway. I think that there's, at least in many of those cases, a strong probability of conviction. As to the child abuse, neglect, or endangerment, I am of the opinion that those cases may not be as strong because of the nature of the statute. That will be something that will have to be dealt with, but I do not place great significance on the strength of those cases. The theft of property and vandalism obviously is a circumstantial case. I have the opinion that based on the testimony that's been offered, that the circumstantial evidence is strong that Mr. Beard was the one who cut the block off, and that was the reason why the theft of water. We can minimize the fact that it may have been a smaller amount of water as what was said, but I think the statute would allow the consideration of the actual amount of water along with any other damage to the property. So I think that there are 2 of the 3 indictments. There's, in this court's opinion, a fairly strong probability of conviction. The sentence to be imposed on an aggravated assault case by strangulation depends on the judge, the sentencing judge, and all of the factors. But it's not an automatic, just because he has no prior record, that he would be entitled to probation. It would be considered, but it is not an automatic thing. As a result of that, the court who hears the case and has to do the sentencing would have to consider all of the sentencing considerations set forth in the Tennessee Code, one of which is the fact that a sentence should be imposed that does not diminish the severity of the offense. And that would be something that clearly the sentencing judge would have to consider. The identity of responsible members of the community who vouch for his reliability. Obviously, those people have appeared today and testified. Any other factors indicating the defendant's ties to the community are bearing on the risk of the defendant's willful failure to appear, including but not limited to whether he is lawfully present in the state. I am of the opinion that one factor that this court places great significance upon is the fact that he violated the bond conditions in the past by contacting Ms. Miller, and that indicated that he did so knowing that he could likely get into trouble and knowing that he was violating the law when he did so, but he did it intentionally. And again, there are ways you can explain it. One of those options is that he was genuinely contrite and wanted to apologize. Another possible explanation is that he, like many other abusers, was attempting to minimize the punishment to himself and to try to sway the victim in the case against testifying against him by apologizing and trying to say that I won't do it again. So, applying all of those factors and considering the severity of this court and the amount of the current bond, the court finds that the bond should be set at $50,000. He will be required, if he makes that bond, to have a GPS monitoring device installed at his expense. He would also be required to pay the expense to make sure that Mrs. Miller would have the ability to monitor that, whatever the law provides regarding that. In addition to that, he is to have no contact with Tiffany Miller whatsoever, by directly, indirectly, by text message, by mail. He'll have no contact with her, period. And that is a court order that will apply whether he makes bond or not. In addition to that, he will only have contact with the minor children that were in his care at the time that he was arrested, pursuant to an order of the Domestic Relations Court or the Juvenile Court. That is, my opinion, an order that is required for the safety of Ms. Miller, as well as, and I take that action and set the amount, and in both the recognition of the severity of the injuries to her and the seriousness of the charge. I have a case many years ago where a young man who was in his 20s thought to present it was a Stewart County case. He thought to try to take one of his friends who was out of line for a ride and straighten him out. He got behind him in the back seat of the car and tied a shoelace around his neck, and thought that was a good prank to try to teach him a lesson. As a result of that, when his friend started turning blue, he kicked him out of the car and panicked and drove off. That man died, and that person is now serving a life in prison as a result of having been charged with first-degree murder. So strangulation of anyone, even in an argument or whatever, is completely unacceptable and is a very serious criminal offense. And for that reason, this court places great importance on the facts that were presented to me, as well as his violation of the prior bond restriction. And I make those findings on the record so that if there is any issue raised about why I have set the bond and made those conditions, it is very clear. That's the judgment of the court.
Judge, if I may ask, just to clarify, did your honor say that Mr. Beard may have contact with the children only as authorized by Chancery of Juvenile Court?
Yes.
Oh, just making sure I had that right.
I mean, if they're his children,
Yeah.
hesitate to say he can have no contact with his own children without giving a court of domestic relations or a juvenile court an opportunity to have a hearing where they could make other findings that would apply as to whether or not he should or should not have visitation or contact with him.
Yes.
All right, we're going to take another recess. We'll take a recess for about 10 minutes. Mr. Hooper, are you next up?
Yes, Your Honor.
You have one or two matters.
All rise.